Would you ask Dr. Lane to come back in, please? All right, Dr. Lane?
Yes, I am.
I think there are
Thank
a
you.
couple of other questions. Is that right, Ms. Gray?
Yes, just a couple of short questions. Yes. I just want to pull back up the Celotex data sheet. So this is RYD 1818155. So that's the data sheet that we looked at this morning that Mr. Ashton is sent on the 18th of September 2014.
Yeah.
Now, just a couple of short questions on this. Would you expect a reasonably competent fire engineer to understand and interpret the contents of such a data sheet in terms of its performance for fire?
Yes.
And Mr. Ashton, having been asked about this data sheet and having been told that the insulation was class 0, would you have expected him to have advised against the use of Celotex RS 5000? So
First I would have first expected him to ask about the assembly and the overall plan
yeah,
for the assembly being compliant. So
Yeah.
he might have asked if a test of that assembly had been done
Yeah.
or for something else first.
yeah. And I think you said this morning that you would have expected him to have advised that paragraph 12.7 of approved document B required the insulation to be of limited combustibility.
Yes.
But would you also have expected him to have said you shouldn't be using Celotex RS 5000, certainly pending clarification of its proper fire performance in that system?
I would expect him to have said that unless you have the valid information for an assembly, I need to warn you that an insulation that only has a class 0 test certificate
Yeah.
is a fundamental breach of the building regulations. Now, I know when I say that other legal profession minds, but in our profession, we do explain to our clients when things are major or minor
Yeah.
non-compliances and the consequences of those in the context of fire legislation.
Yes.
Okay, and I would have expected him to warn them. You said, should he have told them not to use it?
That was the question.
Yeah, so I'm not prepared to kind of take that next step. No, I think his job was to tell them what it meant as a minimum.
Yes, I understand. Thank you, that's helpful.
Yeah.
Mr. Chairman, those were all of the questions that we had.
Right, so you've finished your questions.
I've done my questions. We just need a quick 5 minutes to clean this area, and then Ms. Grogan is going to replace me and
Yes.
ask some questions about CDM and Regulation 38.
I was warned. We now have to do a little bit of housekeeping.
That's fine.
Because there's going to be a change in council.
So do I need to leave?
Yeah, I'm afraid you do. So do
Okay.
we.
Oh, I see. Right, okay.
All right, so we'll have
Yes.
5 minutes. We'll get
Okay.
you back as soon as we can. All right.
Thank you.
Thank you. Yes, would you ask Dr. Lane to come back in now, please? Thank you. Right, Dr. Lane. Different counsel, but more questions, I'm afraid.
Okay.
All right. Yes, Ms. Grogan.
Thank you. Good afternoon, Dr. Lane. We're now moving on to a new area, and I'm going to ask you some questions about Regulation 38 of the Building Regulations and the Health and Safety file under the CDM regulations. You've provided the inquiry 2 sets of reports, and they should both be on your desk, one addressing Regulation 38 and one addressing the Health and Safety file. The first is a report entitled Regulation 38 Fire Safety Information. The first version was dated 31st of October 2019 and consisted of a main report and 2 appendices, Appendix A and Appendix B. You then prepared an updated report, version 2, dated 19th of May 2020, which has 3 appendices, Appendix A, Appendix B and Appendix C. And you've also provided a further updated version of that report dated 26th of October 2020, and that's the one that's in front of you on the desk. That report contains some corrections to typographical errors and additional references to documents and oral evidence, and we can find that for the transcript at the main report is BLARP 2 5021, Appendix A, BLARP 2 607, Appendix B, BLARP 2 5020, Appendix C, BLARP 2 609, and you've also provided a separate document setting out the changes of October 2020, BLARP 2 5019. Does that all sound about right?
Yes.
A long list there.
I hope you're right. Yeah.
Mostly that's reading things in so that they're in the record.
Yeah, understood. Yeah.
Unless I specify otherwise, when I refer to your report,
Yeah.
I'll be referring to version 2 as updated in October 2020.
Okay, thank you.
Can you please confirm that you've not changed your overall conclusions as between the 19th of May 2020 report and the 26th of October 2020 report?
No.
That report focuses on Regulation 38 of the Building Regulations, its application to the various works carried out at Grenfell Tower, including the primary refurbishment, and your review of the building manual for the primary refurbishment. Is that right?
Yes.
And as you indicate in the declaration on section 23, which we can pull up now, that's BLARP 2 5021 at page 300. Should be the next section. Try page 301. There we go. You've provided that report in the same way as you would have provided a report to the court.
Yes.
And on page 302, we see a statement of truth. Is that your signature there?
Yes, it is.
We're going to have to go through this all again now with the next report, which is the health and safety file.
Yeah.
Version 1 was dated 29th of October 2019, and you then prepared an updated report, version 2, dated the 9th of June 2020, and a further updated version dated 22nd of October 2020. And again, that updated version contains corrections to typographical errors, additional references to documents and oral evidence, and we can find that at BLARP 2 5016. And a separate document setting out the changes of October 2020, BLARP 2 5013. And that report focuses on the CDM regulations and in particular the obligation to have and maintain a health and safety file.
As relevant to fire safety only.
Yes.
Yeah.
And again, if we pull that up, that's BLARP 2 5016 at page 192. Again, my page references seem to be out by a page. There's your expert's declaration. You've provided that in the same way as you would have provided the report to the court.
Yep.
And on page 194, is that your signature?
Yes, it is.
And again, can you confirm that you've not changed your overall conclusions as between the 9th of June report and the 22nd of October report?
No, I haven't.
Now, any matters of law within your reports will ultimately be for the chairman and the panel to decide, but can you confirm that the factual matters set out in your reports are true to the best of your knowledge and belief?
Yes.
And can you confirm that your reports accurately set out your true and complete professional opinion on the matters addressed within them?
Yes.
Now, just to outline the structure of your evidence on these topics, I'm first going to ask you about your background and experience relevant to both of these topics. Then I'll ask you some brief questions about how industry professionals approach areas of their work that raise legal issues. And you touched on that briefly with Ms. Grange just a moment ago. We'll then look at Regulation 38 first and the health and safety file after that.
Okay.
And then I'll ask you about the availability of both the Regulation 38 information and the health and safety file on the night of the fire. So that's a topic addressed in both reports.
Okay.
And we'll look at those together as one at the end.
Right.
And finally, I just want to make clear that as Module 1 has focused on the primary refurbishment, i.e. the works which took place between 2012 to 2016, I will not be asking you detailed questions about earlier works or subsequent works to Grenfell Tower, such as the lifts, the fire doors, and the gas main, as these will be covered in detail in Module 3.
Okay.
So just to make that clear. Now moving on to my questions, starting first with your background and experience. Ms. Grange has already asked you about your background and experience, and you've provided an updated CV. If we could go to that, BLARP 25015. And in terms of your experience relevant to Regulation 38, you've set out some relevant experience which starts on page 4 and then goes over to the next page. We see at the bottom there, building manual and health and safety file just at the bottom. And then over again to page 6. We see another, the list of projects continues. Why have you selected these as examples of your experience of building manuals and Regulation 38?
Because that's what I did on the project.
How often does your work involve advising on or preparing information relevant to Regulation 38?
Preparing. So can you say that again? Preparing.
Advising on or preparing information relevant to Regulation 38?
I don't know how often, because it's not something I've ever quantified. But the fire, my role in my role as a fire safety engineer, I explain what Regulation 38 is. And sometimes, if an architect or a principal contractor whose duty it is to deal with completion certificates, if they require further assistance, they would ask me as such on the on projects where I've carried out that service.
So it's right that you have practical experience of working with Regulation 38.
Yes, that's why that's what the projects in my CV are meant to do, and that's a selection. Mm-hmm. Yeah.
And we also see projects that you've set out relevant to your health and safety file experience. I think that's page 8. There. And again, is it right that these show that you have practical experience of contributing to or advising on a health and safety file?
So the 3 projects you showed me earlier, there are 3 projects I selected especially to show where I have had specific experience on the health and safety file and Regulation 38 and providing fire safety information. These are projects where I worked on site.
I see. So on page 6, then the first set of examples that we looked at, that's your
exactly. So that's where I have expressly participated in information in a health and safety file, as opposed to being a user of a health and safety file, which I would be on lots of in an existing building project.
Thank you. That's helpful.
Yeah.
Now, moving on to legal matters, in both of the topics that we're going to cover today, Regulation 38 and the Health and Safety File, the relevant duties and requirements come from legislation, i.e. regulations. That's the Building Regulations 2010 for Reg 38 and the Construction Design and Management Regulations 2015, as well as earlier versions of those regulations. In your reports, you've explained how these regulations operate, and in some cases what you understand the regulations themselves to mean. Can you briefly explain why, as a non-legal professional, you've given a view about the meaning of regulations?
Because it's my job to have read them thoroughly, to understand them as a practicing fire safety engineer, and to have a professional opinion on them. It's not a legal opinion because I have no legal skill. But in my work, I have to understand the requirements of me, if you want to say it that way. So any building I work on, in whatever kind of capacity that is, you know, existing building, new build, I have to give accurate advice to my clients, who whatever type of client that is. So I have to have understood the fire relevant legislation, regulations, statutory and non-statutory guidance. Otherwise, I can't give accurate professional or technical opinion.
And in your professional life, do you advise clients about whether they are or at risk of being in breach of regulations?
Yes, I do, and I'm paid to give advice like that. So I'm appointed on a project or a complexity, and I'm asked to give my opinion, and all it is my opinion, and I have to give it and explain from my technical perspective why that is my opinion. When I say things like that, I'm not thinking about anything else beyond that other, legal experts may think. I understand my opinion may be found to be wrong or less valid than another, for example, fire safety engineer's opinion on the same matter. But I have to explain it to my clients and why. And I'm not unique in that. We do that all the time in our work.
Thank you. And I think you would agree then that the question of the meaning of regulations is ultimately for a court, and in this case, the panel, but you've given, as you say, your opinion on what they mean because it's relevant to your professional role. Yeah,
so I feel I have to do that. So when I've done a lot of work with principal contractors, as I've said, and when you're coming up to the end of a project, it can be a very frantic time, getting all the paperwork, getting everything built, making sure everything's okay. And sometimes when projects are handed over, there may be some work left outstanding that you do after handover. And that's a really important time where you explain major and minor non-compliances. And if a client should allow the handover and let minor non-compliances occur afterwards. So in that space particularly, you have to give a view. And you live with the consequences of that view also.
Thank you. Turning now to the topic of the Regulation 38 information, and looking first at Regulation 38 itself, and we can turn that up in your report at BLARP 25021, page 9. And it's that top half of the page there you've quoted from Regulation 38. And looking first just at the type of work that it applies to, we can see that at 38A. It applies to work which consists of or includes the erection or extension of a relevant building, or is carried out in connection with a relevant change of use of a building, and Part B of Schedule 1 imposes a requirement in relation to that work. Is that right?
Yes.
And moving down then to 38 subparagraph 2, it says the person carrying out the work shall give fire safety information to the responsible person not later than the date of completion of the work or the date of occupation of the building or extension, whichever is the earlier. And then beneath there we see some definitions. Fire safety information is defined as information relating to the design and construction of the building or extension and the services, fittings and equipment provided in or in connection with the building or extension, which will assist the responsible person to operate and maintain the building or extension with reasonable safety. And a relevant building is defined there as a building to which the Regulatory Reform Fire Safety Order, the RRO 2014, applies. And then a relevant change of use is a material change of use, where after it takes place, the RRO will apply or continue to apply, and responsible person has the same meaning as in the RRO.
Yes.
And now we can see your analysis of the primary refurbishment and why it was a relevant change of use in a later section of your report. And if we go to that, it's page 103 at 13.4.7. And you say there, the works described by the full plan submission for the primary refurbishment works also touched every part of the rest of the building from ground floor to the roof of Grenfell Tower. Can we take it that your view is Regulation 38 therefore applied to all of the works that comprise the primary refurbishment?
I think that fire safety information was needed for fire safety works during the primary refurbishment.
So it would not just apply to the parts of the refurbishment that were a material change of use, so the changing into the flats on the lower levels.
I see what you mean. So, well, you've left. There's an extra part of material change of use, but anyway. So, on the lower floors were a material change of use, but you still have that duty because of the building, because of the height of the building, to consider B4. And the cladding occurred on all the floors. And the fire safety systems, their extension into the new floors, they don't exist in isolation. So in my opinion, it's very hard to cut off different parts of the fire safety works and divvy them up into pieces you would explain and pieces you would not explain under Regulation 38.
Yes, I see. So we can see it just above, actually, 13.4.6. I skipped a step. You've explained there that the works included a material change of use. And you give your reasons, which is the dwellings were increased and also new flats were introduced that did not previously contain flats. And then you go on to say those works also touched every part of the rest of the building.
Yes.
And so taking all of that together, your view is that you had to submit Regulation 38 information relating to all works rather than just the new flats.
So you had to submit Regulation 38 information, which is fire safety information about fire safety works that impact fire safety.
I see.
Yeah.
Are you aware of a contrary body of opinion on this issue? So a body of opinion that believes that you would only need to present information relevant to the flats themselves?
The flats?
Yes, the new flats.
So inside the flat, no. Outside the flat, do you mean that so outside the flat, because the flat demise is a different issue, because anyway, so outside the flats, the new flats in the common parts, I think you're asking me if some people might think they just needed to explain that with respect to relevant fire safety information.
Yes, that's what I'm asking.
But as I've explained, the smoke control system doesn't operate independently on that floor. The cladding doesn't exist independently on those stories only. There was sorry, excuse me. I'm trying to think what else. The lift shafts were extended. They don't exist in isolation on those floors. So when I take every single part, if you wanted to take that view, the substantial changes on the lower floors are in a fire, don't exist in a separate kind of a cut-off place. I'm probably not verbalising that correctly. Yeah.
No, I understand. I
Yeah.
understand what you mean. I think the point I'm trying to get at is there a rival view in the industry that you would just look at that area?
Oh, sorry, no, not that I'm aware of.
Thank you.
No.
The obligation to comply with Regulation 38 rests on the person carrying out the work.
Yes.
You've given your understanding of this concept at 2.18 of your
Yeah.
report.
Yeah.
And if we can go to your analysis, it's on page 24. And we see there the heading person carrying out the work.
Yeah.
You start there by saying that there's no definition provided in the regulations of
Yeah.
person carrying out the work.
Yes.
And it's also not defined in any approved document or fire safety procedural guidance.
Yes.
And you then say at 2.18.3 that for the purposes of this report, you've defined the person carrying out the work to be the organisation with primary responsibility for and in primary control of undertaking the physical construction
Yeah.
work.
Yeah.
And then you set out a little later the factors that have helped you in reaching that interpretation.
Yeah.
Now, the inquiry has heard from Ms. Menzies
Yeah.
that she considers the person carrying out the works to be the owner, or at least the owner is one of the
Yeah.
candidates.
Yeah.
Does that, now you're aware of that evidence, does that affect your view at all?
It doesn't affect my view, but I think it's a very interesting point. And I also, like Ms. Menzies, I read her report last week, have experience of working with a client body where they have a contractor arm that does work and hands over to the landlord unit in the same organisation. So on paper, it might read that you're handing over the information to yourself, as such, as a client body. But so I have experience of that, where there's an in-house contracting team and they hand over to the in-house responsible person, and there's an exchange of information that way. And that does happen. Currently, I don't equate that situation with KCTMO. I am, however, at this time, looking very carefully at the communications between Claire Williams and Janice Ray around this time period in my Module 3 work. And if I found something there that changed my view, I would make it clear then. But at this stage, and I have read a lot of evidence around that interrelationship so far, as far as I'm concerned, Ryden were in that position. They're not part of KCTMO. They were in control of the works. They could assemble that information and give it to the KCTMO as an organisation. This next step about what happens in the KCTMO is a very valid one, and I am still looking at that.
And so just for clarity, your view is that on the Grenfell primary refurbishment, it was Ryden who are the person carrying out the works?
Yes, as I said, yeah.
Yeah.
But you asked me if, what Miss Menzies said raises something, and yes, it does.
Thank you.
Can I ask you this? Just thinking of the actual arrangements
Yeah.
for carrying out a construction project
Yeah.
and the nature of the information that has to be handed over,
Yeah.
which person is likely to be best equipped to produce that information?
Yes, in my opinion, on the Grenfell project, it was Ryden as principal contractor. Yeah. And my own experience is the principal contractor running that process of gathering everything together.
And am I right in understanding, we've had some evidence about this, and we've
Yeah.
touched on this, that in principle, the health and safety file is intended to be maintained as you go along.
Yeah, so that's the other file. Sorry, I'm probably confusing everyone now.
No,
So the
I'm-
Regulation 38 information is different to the CDM information on Grenfell. It was all merged together.
Right.
Okay.
So my question then really ought to be who is in the best position to produce the CDM file?
The health and safety file, well, there's a legal duty to produce the health and safety file, which is separate to this Regulation 38 fire safety information. So at the moment, we're talking about the fire safety information for the building manual under this particular regulation, and that is different to the health and safety file required under CDM.
I think I'm responsible for the confusion.
Sorry, yeah,
but-
no, I didn't want to.
No,
sorry.
no.
It's a total, it is
But let's just go
horrendous,
back
yeah.
to it, because one of the ways in which you might reach a decision about who is responsible for producing
right.
this file,
Yes.
who is best placed to do it,
Yes,
because if regulations will work better in one sense than if you give them a different sense, that might affect one's
yes,
approach to the construction. So
yeah.
this is why I ask you, who's best placed to do the job that the regulations require to be done?
So when it comes to communicating works and the fire safety, the fire safety information about works, I have always said, to be honest, it's the principal contractor. Okay. If the definition was very clear and caused that to become someone else, I understand that may happen, but the principal contractor understands what's happening, has the has his or her subcontractors, is programming it, knows where everything is, knows where all the paperwork is. So that's why I always attribute the assembling of the information to them.
Yes, thank you.
Yeah.
Yes, thank you. It is confusing because we're talking
No, I
about
know.
various different manuals as we go along.
Yeah, and I think, I think, so because it is really confusing. So can I just say, so at Grenfell Tower, there was one building manual with several parts, one part of which was the health and safety file. The rest of the parts were not the health and safety file, okay? And yeah, it takes months and months and months and months to work all of that out for Grenfell. Yeah.
Yeah, thank you.
Yes, and we'll come on, your report, your Regulation 38 report also refers to a fire safety manual. We will come on to that
Yeah.
and explore what that is and,
Yeah.
and how it fits in a moment. Staying with the person carrying out the work,
Yeah.
besides the organisation with primary responsibility, so besides the principal contractor, are there any other potential candidates for a person carrying out the work, just in principle? So designers, or would it ever be the case that it was someone else who was a person carrying out the work?
No.
And in your experience, what was the prevailing understanding of who the person carrying out the work is?
Oh, honestly, I've never asked anybody.
Is it not something that's come up?
No.
It's not something that was confusing or led to people to be confused at the time?
Not that I'm aware of, no, I'm sorry. Yeah.
And I'm going to move on and ask you some questions about the guidance supporting Regulation 38. And we're still sort of working through what Regulation 38 means and what it requires. So you've identified a number of pieces of guidance that support Regulation 38. And if we can look at those in a list, it's 11.1.4 on page 72 of your report. And there you've listed out 3 sets of guidance, procedural guidance produced by what was DCLG, and then after that, a 5th edition produced by the LABC. Appendix G, Fire Safety Information of Approved Document B, and Annex H, Fire Safety Manual of BS 9999 2008. Starting first with Approved Document B, you've explained at 11.3.8, page 76 of your report, that the guidance in Appendix G hasn't changed since ADB was first issued in 2006. Is that right?
Yes.
Yes. So there are no relevant changes that we need to concern ourselves with. And if we can then just go to ADB, CLG 50173, page 149. That's Appendix G there. And if we look on the left-hand side, just above, so it's the second half of the page. If we look down on the left-hand side, just above the heading Simple Buildings, it says this appendix is only intended as a guide as to the kind of information that should be provided. For clarity, the guidance is given in terms of simple and complex buildings. However, the level of detail required will vary from building to building and should be considered on a case-by-case basis. Given that it says there that the appendix is only intended as a guide, does that tell us anything about how strictly it should be followed, or does it distinguish Appendix G from the rest of ADB in any way?
I don't think so, no.
It then goes on to give guidance for simple buildings and complex buildings, but it's right that it doesn't actually define what a simple building is or what a complex building
Yeah,
is.
that's correct, yeah.
And in your opinion, was Grenfell a simple building or a complex building?
Well, I personally think it's a complex building.
What features in particular lead you to that view?
So it was a high-rise residential building, which, if it was being built now, it would require sprinklers. Didn't have sprinklers. It was undergoing a complex overcladding project with different materials. It was. It needed a new smoke control system. And the designers had to work within the constraints of the existing building. So they didn't have free rein over how to develop a smoke control system. And also, no, I think they would be my 3 main points. I think I gave a longer list in my report, but after a day and a half, I can't remember everything off by heart anymore. I'm sorry, but I did actually give a list.
You did.
In my report.
It's section B2
Yeah.
of Appendix B. Would you like to go there, or I can just give the reference for the transcript?
No,
if
I
you
don't
want to
mind.
see it?
But I think for me, there are 3 complex things, very complex things.
So for the transcript, we don't need to go to it. It's BLARP 2 5020, page 7. And that sets out the features. Do you agree that Grenfell could be considered to be a simple building, or at least that another expert might come to a different view from you?
Do I agree another expert could come to a different view?
Could reasonably come to a different
Could reasonably come to a different view. Well, I've heard another expert say that. Miss Menzies said that.
Under the guidance for complex buildings, which we can see on the right-hand side, the page is in the right place, we can see it says, oh no, sorry, we do need to move up a little bit. To where it's point 3. For more complex buildings, a more detailed record of the fire safety strategy and procedures for operating and maintaining any fire protection measures of the building will be necessary.
Yeah.
So that's the guidance saying what kind of Regulation 38 information should be provided for a complex building. Is that right?
Yes, it says operating and maintaining just as Regulation 38 itself. They're the two.
Yes.
Yeah.
And then it says there, further guidance is available in BS 5588/12/2004.
Yeah.
But it's right, isn't it, that British standard was replaced by BS 9999/2008.
Yes.
And therefore, what you've done is you've gone on to look at that British standard in your report.
Yes, as a guide. Yeah.
As a guide to the kind
Yes.
of information
Yes.
that Regulation 38 requires. Now, in terms of a complex building, ADB Appendix G itself also tells you a list of things that the records should include. And we can see that there just starting at little a and going over to the next page. And then BS 9999, you've already mentioned it, you'd agree that's an additional source of guidance about all the things that should be included.
Yeah, it gives you more practical information about what to actually do. Yeah.
Is it building on that list there in ADB?
Yes, it is, yeah.
Now, it's right that BS 9999, it's not prescriptive. There's no requirement that says you must follow it. Is that right?
Yeah, it's a British standard.
And if Grenfell was a simple building, and we know you don't agree with that, there would be no need to refer or attempt to follow BS 9999.
Because it doesn't say it at point 2.
Yes.
Well, actually, can we just scroll up to the top of the page so I can see the rest of the list of a simple building, please? Sorry, excuse me. Yeah. I mean, I think I find this point kind of a little bit difficult in the sense that even for a simple building, if it had very simple matters from A to J under point 2, if I was trying to work out exactly what to do about that, I think the 9999 offers just some practical help about what those words mean, as opposed to it's saying don't read the British standard if it's a simple building and only read the British standard if it's a complex building. So I'd struggle a little bit with that.
Yes, thank you. And just to give the panel and the public an idea of the differences between a simple and a complex building, is there a great difference between the kind of information you should be providing for a simple building and for a complex building?
Is there a great difference?
Yes. Are they completely different things that you have to provide, or are they all?
So I think that in order to operate and maintain a building, there are certain things that you need to know. I don't think they change. I don't think that you can operate. I don't think they change because a building is simple or complex. It's the scale of information that changes rather than the quality of the information that changes.
Now let's go and look at BS 9999, and you've helpfully extracted bits of it in your report. If we go to 11.4.11 on page 78 of your report, so that's there. And we look at that quotation there, which gives an overview. And I just want to look at the last sentence, which says, fire safety procedures and maintenance schedules are developed at the design stage and included in the fire safety manual, which is handed over to the person responsible for fire safety of the building in order to enable a suitable and sufficient fire risk assessment to be carried out. And then underneath you say the fire safety manual is therefore described as a specific piece of documentation for the building.
Yeah.
Can you just help us understand? We obviously have Regulation 38 and the requirement to hand over fire safety information.
Yeah.
How does the fire safety manual fit in with that? Is it fair to say that it's one way of providing the Regulation 38 information?
Yeah, I think fire safety manual is like it's a loose description of something. It's not an entity in itself, maybe is what you might be asking me.
Yeah, it's not a term of...
Yeah, it doesn't have a fire safety manual is the following.
Yes.
To me, it's a concept where the important part of Regulation 38 is that the fire safety information the responsible person needs to do all sorts of different things, and we'll be covering that in Module 3, is available for that responsible person. So, because when they take possession of the building, they have to set up a fire risk assessment process, they have to set up a maintenance programme, they have to write an emergency plan, they need to brief the fire brigade on what measures are being provided to them. So they need information. I wouldn't criticise anyone for, the visual aspect of the information. So it's that the information is provided.
So if you don't have a nice document that says fire safety manual on the front of it, that doesn't matter so long as the actual information that's required has been handed over.
So if you have a building manual, I would expect to see a fire safety manual register or table of contents that refers to the correct part of the building manual that contains fire safety information. I wouldn't expect someone to reproduce parts of a building manual, put it back into another massive set of folders and call it a fire safety manual. I seem to actually be losing my voice this afternoon. Sorry, excuse me. So once you explain where the fire safety information is, in my mind, you are delivering a fire safety manual.
Thank you, that's very helpful. Annex H of BS 9999 then sets out what a fire safety manual should contain. And again, you've reproduced that in your report on page 78 or at 11.4.16, so it's a little further down this page. And the text there says the design information forms the basis of an ongoing history document to which additional material is added when the building is occupied and at regular intervals thereafter. The designer is largely responsible for those parts of the fire safety manual that contain design information. Further information is given at H41. And the fire safety manager is responsible for those parts of the fire safety manual that contain operational records, the fire safety policy statement and the fire safety documentation. Where a building is being refurbished, so not a new build, is it expected that a new fire safety manual should be produced for that refurbishment, or is it expected that an existing fire safety manual will be updated?
If there was an accurate existing building manual and you were relying on information in it, you would then add in any additional information that was required. But that's a hypothetical, isn't it?
It says there that a designer is largely responsible for certain parts of the fire safety manual. How does that fit with the obligation under Regulation 38 for the person carrying out the work to provide fire safety information?
Because there's a gathering exercise of information. The designer doesn't disappear as such.
Well, in this case, the designer is the contractor.
Well, I was actually about to say that, but I was afraid to open up another can of worms. That yes, they were, and they are in fact listed as a designer on most of the F10 forms as well. So, so if you're asking me if it wasn't a design and build project, so we're back into hypotheticals again. The designer and the contractor is putting information together, and there will be one party more responsible. I don't want to get into that because that's not what happened at Grenfell.
Okay. Moving on then, at 11.4.21, which again is on page 79, we see the beginning of a very long list of information that's to be included in the fire safety manual, and it goes over onto page 80. And it's right that this is the list that you've relied on as the basis for your analysis. of what happened on Grenfell Tower.
Yeah, and some of it applies and some of it doesn't.
Yes, and you've made
Yeah.
that clear
Yeah.
in your reports. And as you said, this list provides further practical guidance building on what's in Appendix G.
Yeah.
As both approved document B and BS 9999 are guidance rather than regulations themselves, is it in principle possible to comply with Regulation 38 by some alternative means, so by not following this guidance and doing something different?
Well, as the information needed to operate and maintain a building is the same, it's kind of a redundant point, you know, what order you assemble it in or what it looks like at the end. The information is the information. Yeah.
Moving on now to the scope of Regulation 30 information, Regulation 38 information. The regulation itself says that the information provided should be that assists the responsible person to operate and maintain the building or extension with reasonable safety.
Yeah.
So the focus there is on information that assists with operation and maintenance. Is that right?
Yes.
And also information that enables the responsible person to comply with their duties.
Yeah,
under
their
the
later
RRO.
duties. Yeah. Yeah.
Do you agree that information which is already in the possession of the responsible person,
Yes.
or information that might not assist them in achieving those objectives, falls outside of the Regulation 38?
Yes, I do. But again, that's a hypothetical situation, in my opinion. And the information under the RRO we're covering in Module 3.
I mean, that really is a question of construction, isn't it? But what I
Yes.
think the witness could help on is whether there are matters in the context in which these regulations have to be applied, which would help one to understand how they ought to be interpreted.
I see, yes.
So, you say that in your view, if I've understood your last answer correctly, it's not necessary to include in the fire safety information
Yeah.
information that is already in the possession of the responsible person.
Yeah. So, yeah.
Is there any particular reason arising out of the nature of the works and so on that
Yeah.
leads you to that conclusion, or is it, in your view, just a matter of common sense?
Yeah. So, if a refurbishment, so let's take the lifts at Grenfell Tower. They remained. So, you know, there wasn't a massive lift refurbishment. They remained. So you would expect the existing building manual for Grenfell Tower contained the relevant information for the responsible person to carry out their duty. So then I wouldn't say Ryden should have found that information, okay? It should exist already. Ryden are then providing fire safety information for the things they've changed, replaced, created only. Give it to the responsible person and they can incorporate that with any existing fire safety information that remains valid after the refurbishment. So they're going to rely on the lifts or rely on something that existed all along. And then they would combine them.
I can see that, but I can also see an argument for saying it ought to be all in one place,
So,
and therefore
yes.
that any new provision of information ought to contain everything.
Yes,
But,
I would expect it to be all in one place. Again, it should be in one place, and I'm just a bit conscious about straying. So we will be talking in the future about where information was stored at the KCTMO, existing information, and then this new information coming in and how that was dealt with then, yes. And I could answer your question more appropriately then.
Right.
Yeah.
We will come
Yes.
on to that.
Is that okay? Yeah.
And again, just assisting with context, during a refurbishment project, for example, or even a new build, as the client, and in this case also the responsible person, the TMO was receiving
Yeah.
fire safety relevant information as the works progressed. does that mean that in practice you wouldn't need to have a compendious set of information handed over at the end because, for example, the TMO already had fire strategy drawings in its possession throughout the works?
No, I think as we've been talking about a lot in the last day and a half, there's an exercise needed at the end of the job. Remember, the fire safety information is meant to reflect the as-built condition, not things as they go along. Okay? So there's a sweep-up exercise at the end. The drawings and all the relevant fire safety information reflect the as-built condition. And yes, there is a moment when that needs to be handed over. It's not necessarily about the incomplete or superseded information as you go. And the as-built is a really important word. Yeah.
Moving on now to the completion certificate and how Regulation 38 fits in with that. On Tuesday, the inquiry looked with Ms Menzies at Regulation 17 of the building regulations. And it's right that a building control body has to satisfy itself that Regulation 38 has been complied with before it can issue a completion certificate. I want to explore with you how, in your experience, a building control body goes about satisfying itself that Regulation 38 has been complied with. And in your report, you go to the fire safety procedural guidance, which gives guidance about Regulation 38, among other things. If we look at page 83 of your report at 12.2.1, you've provided an extract there, and at the bottom it just sets out the legal status of the guide. It says, although this guide has no legal force, it's intended that all building control bodies and fire safety enforcement authorities should use the consultation procedures described in the guide as a model for arrangements they make, so that procedures will be similar throughout England and Wales. But you have given your opinion, and I just want to ask, was it your understanding at the time of Grenfell, so 2012 to 2016, that whilst this guidance has no legal force, it's nonetheless important guidance to take into account?
Yes.
You've identified a change in the guidance between the 4th and 5th edition, and we can look at that at a table on page 93. And you provided some excerpts there, and it's the highlighted text at the bottom. You'll see the 4th edition says that for Regulation 38 information, a copy should also be sent to the building control body. And on the right-hand side, that text is no longer there in the 5th edition, and it simply says that a written confirmation to the building control body should be sent where Regulation 38 information has been provided. And we've heard evidence from Mr Hoban and Mr Allen that RBKC had a practice of accepting a verbal assurance that Regulation 38 had been complied with. That guidance there doesn't mention a verbal assurance being acceptable.
No, it doesn't.
Were you aware of this kind of practice in the industry at the time?
Yes, I am aware of that practice, yes.
How widespread was it?
How can I answer a question like that? I mean, all I can tell you is that as a fire safety engineer, remember, we don't run that process. We assist an architect or we assist a contractor. The last experience I have on this matter, I was, before the fire, I was helping a principal contractor, and in that particular circumstance, building control asked the principal contractor to lay the manual out on a very large table, I have to say, lay all the manuals out, and they observed other things on site, and then they asked us in our particular capacity on that job if we considered the building manual to contain an adequate quantity of fire safety information, and we had to discuss that with them. So they did it that way. That is my last experience. But I'm also aware that that does not happen on our projects.
And on your projects, and you may not be able to help us with this, did you detect any change in practice as between the fourth and fifth editions? So when the fifth edition came out, did you notice building control bodies stopped asking you?
I would be of the view, and I would be of the view, and in the work that I've been doing, is that Regulation 38 hasn't really had a huge priority for some time.
And you've concluded in your report, and we can look at that at 12.5.18 on page 95, that your view is that the current guidance doesn't enable a local authority to issue a compliant completion certificate in accordance with Regulation 17. Why do you say that?
Yeah, I feel that change in the procedural guidance, where you go from, being expected to actually check something, and the professional design team having to go to make an effort to display relevant fire safety information and share it, to simply accepting a verbal confirmation is a reduction in standard. I don't know how an authority can cope with that. I mean, my own experience of trying to, that handover is a really fraught, complex time, trying to finish the construction. People want to finish up on the job, trying to gather all that information. It's very, very difficult. Everybody in the industry is aware of how difficult it is. So for an authority to just have to accept a verbal assurance, it's a very light way of dealing with such an important transfer of information to the person who now has to start running that building.
Moving on now, I'm going to ask you some questions about the primary refurbishment itself and what happened with the building manual. Now, just to establish some parameters, we know your view is that Regulation 38 applied to the primary refurbishment. We've been through that already, and we've also heard that your view is Ryden was the person carrying out the work. You've also set out in your report at page 183 some of Ryden's contractual responsibilities. So we see there at 16.2.5, Ryden had a responsibility in its contract to comply with statutory requirements and to obtain statutory consents. And then you've also referred at 16.2.13, which is over the page, to Ryden's obligation to produce a building manual. And again, just so we're clear, and we've touched on this briefly already, the building manual, and the reason why we're talking about the building manual today is because that is the means by which Regulation 38 information was passed, or could at least in principle have been passed.
Exactly. That was the vehicle or the process where fire safety information could have been passed. And that's how it happens on the projects that I work on.
And does anybody actually identify the contents of the fire safety information?
So in the work that I have done, I have been asked to produce a document. It's almost like an index setting out what's required and on the project which party should provide the information. Okay? And I call that a fire safety manual index.
Well, what I was really thinking was it was your evidence about verbal assurances.
Oh, yeah.
That started my mind working. I mean, if you only have a verbal assurance, you have no evidence of that anything's been handed over, and almost as importantly, you have no idea, even if you accept the insurance, what has been handed over. Do you?
I couldn't agree with you more. That's exactly the situation that the building control officer finds themselves in. Okay.
Yeah. Now, if you give the fire safety information as part of the building manual,
Yeah.
or within the building manual,
Yeah.
is it normal to identify which parts of the building manual are considered to provide the fire safety information?
Yes, yes, that is what we do. Yeah.
Thank you.
And you've also mentioned that in your experience, there are some building control bodies who would sit down and ask to see bits of the building manual. I think you
Yeah, they
mentioned
want to
that earlier.
physically, because I mean, it's exactly as the chairman has just said. It's almost like it doesn't even exist. You just ask a question, you get an answer. So the last project I did, they wanted to see that it existed, and they wanted assurances that parts of the manual contained the relevant fire safety information.
At 16.2.20 of your report, which is on page 185, you've said you also note that KCTMO were responsible as a client to ensure that their appointed contractor was fulfilling their required duties, and that they appointed Artelia as their agent.
Yeah.
In the context of Regulation 38 information, when you say KCTMO was responsible to ensure Ryden was fulfilling their duties, what do you mean?
Well, I think what I was trying to say is sometimes I've been asked by an organisation to check the building manual they're going to receive to make sure when it comes to the fire safety information that it's there and accurate. So, because again, it's a bit like the building control officer just accepting. You know, some organisations will want some assurance from another party that the building manual is complete and accurate. Because, as I've said, it's very, very frantic towards the end of a project, simple or complex.
And just to draw out a contrast to CDM, which we'll
Yeah.
come to, under CDM, the client actually has a regulatory obligation
Statutory
to
duty, yeah.
check.
Yeah, agreed. Yeah.
But there's no equivalent obligation under Regulation 38
No.
for the responsible person
No.
to do any checking.
No.
But as we've heard from you, some do choose to do that.
Yeah, so it's an assurance rather than a duty, yes.
In your experience, would a client or responsible person such as the TMO have the skills and expertise to be able to police what a contractor had provided them?
In my experience, should they or did they?
Did they?
Did they police Ryden?
Well, so in principle, a client in the position of the TMO, would they be equipped to look at the information provided and actually say, well, that's not right and I want this done differently?
Okay. Well, the KCTMO have a lot of properties. They had a lot of operating and maintaining duties already before this refurbishment. So that branch of KCTMO could be expected to know what they needed because they were already doing it.
Yes, that's
okay.
that answers the question.
Uh,
Moving on to Artelia, you've referred to their contract with the TMO.
Yeah.
In particular, we can see it up on screen
Yeah.
that you've highlighted two
Yeah.
of their obligations, 1.5.9 and 1.5.10.
Yeah.
What do you say the role of an employer's agent was?
Well, I explain. I
38.
kind of explain that later in my report as well. That again, my experience is when the building manual is being handed over to a client, the employer's agent might check it for completeness, may check that it contained what the contract asked it to contain. Because the contract as I read it technically, set out a list of information that was expected in each part. It was quite comprehensive and helpful, actually, in terms of what should go into each part of the building manual.
We can see that, we can see your view at 16.3.61, which is, sorry, I should give you a page reference. That's on page 194. And you say there, I acknowledge an employer's agent would not directly review the technical content of all parts of the building manual.
Yeah.
But in your experience as a practicing fire engineer, given that they're signing the practical completion certificate, you'd expect them to satisfy themselves that O&M manuals were in place, complete and technically approved by the relevant consultant.
Yeah, because, exactly, because the fear, remember, about handing over that certificate is everyone kind of packing up and leaving before the information has been gathered. So there, my experience is you do as much as possible before this certificate is issued, just to make sure all the companies take the time to put the information together.
And in broad terms, it's dealt with in your report. Did you see evidence of that checking process taking place by Artelia on this project?
I was surprised to read, and I've got the reference in the report. At some point they said something like, that's not part of our, I can't remember, sorry.
16.3.62, there's an email which
oh, yes, sorry.
we won't be reviewing the O&M manual.
Yeah, no, sorry, excuse me. Yeah, I was a bit surprised to read that. I mean, I'm not making a big, massive point about this, but I was surprised to read that because my experience is that, the certificate is issued, obviously to do with the state of the construction, but also that the information is in good shape. And I have experience of giving a view, for example, that the information is complete enough that the missing pieces can be called a minor defect, or that the information missing is a major defect, and we strongly recommend the certificate isn't issued and they really get everyone to focus on putting that information together.
Now, we know that Ryden subcontracted the preparation of the O&M manual to a company called All Group Holdings.
Yes.
How common is it for contractors to subcontract the preparation of a building manual?
Yeah, I have observed that happening, yes, and I don't have any, that's absolutely fine in my mind.
How can the subcontracted company know enough about the project to be able to compile fire safety information?
Well, typically they will have to be around for a while and have to spend time understanding what each party is doing. And they will have my experience is, a very specific, detailed list of things that they will have worked on with the principal contractor to compile, and then their job is hunting people down, quite frankly. Yeah.
And in your experience, do companies that are subcontracted to do this kind of work, do they advise on Regulation 38? Do they tell the contractor what needs to be included?
No.
So that's for the contractor. The contractor should know already, in your view.
The person who's applied, the person who's paid to get the completion certificate needs to understand that, who's paying the fee yeah.
Have you seen any evidence that All Group Holdings were specifically asked to consider or compile fire safety information? So do you see...
In the context of Regulation 38, no.
Yes.
But were they asked to get information about fire safety systems? Yes.
You've noted in your report that the instruction to proceed to All Group Holdings came on the 11th of March 2016, and at the time that was 4 weeks before scheduled completion of the works, although completion did happen later.
Yeah.
In your experience, was that sufficient time to compile a building manual for a project such as Grenfell?
I think that's a very short period of time.
Moving on now to your analysis of the building manual. You've been provided with 2 versions of the building manual, one provided with Ryden that you received in 2017, and then one provided by the TMO that you received in 2020. And it's right that your report now provides an in-depth analysis of the building manual provided to you in February 2020, so that's the one from the TMO.
Yes.
And we've already established that the Grenfell O&M manual does not include a self-contained package of information that purports to be Regulation 38 information, does it?
Yes.
And there's no index, as you said, identifying where the fire safety information is.
No.
You've carried out a detailed analysis of the manual in sections 18, 19, Appendix B and section 20 of your report. And is it right you've done that because you've looked to see if, notwithstanding that there's no index, the manual itself does in fact contain the relevant fire safety information?
Yes, I did,
I just want to highlight some of your key conclusions arising out of that analysis.
Yeah.
And I've got a few specific questions for you along the way. If you go to page 233 of your report, and it's 19.2.2 and 19.2.3, you point out that the manual did not contain an as-built fire safety strategy and did not include Exova's outline fire safety strategy. We know that Exova's OFSS version 3 had already been issued to the TMO. In those circumstances, did it need to be in the O&M manual?
A fire strategy that reflected the as-built condition needed to be in the building manual, and it was not.
And if it had been included, was the outline fire safety strategy that Exova drafted adequate to satisfy the requirements of Regulation 38 or the guidance in BS 9999?
No.
At 19.2.9, which is on page 235, you say that the information about active and passive fire protection measures is spread across 5 different parts of the manual containing 2,000 documents, some of which are substantial in length. Is that right?
Yes.
And in the next paragraph, you identify that there are sections of the building manual that are blank and contain no information.
That's correct.
Does that include sections where fire safety information ought to have been provided?
Oh, I'd have to. No. So I did that summary table in the appendix, just showing where the empty files were. I don't know that off by heart now.
We can go.
Yeah.
We can go to the appendix in a moment. At 19.2.13, you say that another issue is that a comprehensive O&M manual is not provided for all fire safety systems, meaning that the responsible person is not provided with the necessary fire safety information to fulfil their duties. And at 19.2.14, you say there are parts of the building manual which contain what appear to be sufficient information, but when I interrogated the fire safety information, significant issues emerged. And you've used the external wall information to provide a more detailed example of this in section 20, which we'll come on to in a second. Would it be fair to say, as a way of summarising all of that, that the building manual is not complete with regards to fire safety information?
Yes.
To the extent that information is present, it's difficult to locate within the manual.
Yes.
And even where there is some information, it's often inadequate to enable the responsible person to discharge their duties.
Yes.
Anything else by way of summary?
No.
That encapsulates it. At paragraph 19.2.15, you go on to say that that's not unusual compared with your own professional experience over many years. How does the refurbishment O&M manual compare with building manuals that you've seen for projects similar? Is it of a piece, or is it substantially better, substantially worse?
I think it's as bad as the bad manuals I've reviewed in my life. But there are, just, it's this thing, I've also worked with lots of people who've tried to do their best as well in the last 23 years. And so I've also seen building manuals that were very clear and allowed me to make appropriate decision making appropriate decisions in a building when I needed to do some work.
Now looking briefly at the external wall information.
Yeah.
You've analysed that in section 20 of your report. And if we just go to your view at 20.6.1, which is on page 285.
Yeah.
You say there, that on the basis of the evidence you've presented, you concluded that the person carrying out the work did give some fire safety information to the responsible person,
Yeah.
but that information could not assist the responsible person to operate and maintain the building with reasonable safety.
Yeah.
And in terms of the facade, that's because, as you say in the next paragraph, you've shown that the information provided did not describe or provide information about the performance of each as installed component.
Yes.
And you also note that most substantially, it's because the materials themselves chosen were not compliant with the requirements of
Yeah.
Approved Document B.
Yes.
My question is this a failure not so much a Regulation 38 failure, but more of a fundamental failure to comply with B4 of the building regulations?
Yeah, so I think the information, so when a company is, submitting their information to the building manual, so we would have to do that in Arab. It's almost like the last time sometimes you have to check that, the advice was accurate, the information reflects the advice, and that it all complies then, say, with the fire safety objective set. So it's an important last set of checks, really, before you hand over a building.
So that was my next question is, given the as-built condition of the facade was
Yeah.
what it was,
Yes.
and that Regulation 38 information could only reflect what was as-built,
Yes.
if the O&M manual had sort of clearly identified all of that, should it have prompted any review of the design even at that late stage?
So, okay, so I think you're asking me to contemplate when Harley were assembling their part of the building manual, did they check each component of a final fire strategy that contained the performance criteria and do a final check that the certs and the information they had aligned with those performance requirements?
Yes, did that check?
But first of all, that couldn't happen because that wasn't written down anywhere. And then obviously I don't know what Harley did when they put their information together.
But as we've sort of explored, given that you could only present as-built information, is it right that these are failures to comply with Regulation 38?
Oh, do you mean that you're allowed to provide as-built information that's wrong and you still have discharged your duty under Regulation 38? Is that what you're asking me?
Well, yeah. How does that work in circumstances where you have a non-compliance?
Well, you're not meant to have you're not meant to hand over a non-compliant building in the first place.
And does the Regulation 38 process provide any additional check or layer of protection against that?
Well, you might hope that it would. Actually, can I just add something to that? I think I addressed this in this report. The TMO were asked about the cladding by the fire brigade, weren't they? In that letter, a few months or weeks before the fire. And the chairman was asking me about how the TMO, if you've existing information and new information. I mean, from what I can see, the evidence I have is they didn't seem to go to any building manual when that question was asked. And I think that's another important point to make.
So when you refer to the letter from the LFB, that's a letter that was sent not just to the TMO, but it was asking after Latinal House for details.
Yeah. And that because I think sometimes people go, why does this matter? Well, that was a really good example of where you would open up the building manual and again check the information you have, check that it is all accurate and compliant, and have another opportunity to work out what that might all mean, having been asked.
Ms. Grogan, how are we getting on? I'm thinking it's time we had a break soon.
I was just thinking that myself. We have come to the end of Regulation 38, actually, so now
Well,
would
that's
be
a very good
great
time then, isn't it? Yes.
Good.
Well, right, yes, exactly.
Thank you. Yeah.
Take a short break.
Thank you.
Half
Yes.
past 3, please.
Yes,
No talking when you're out.
I won't.
Thank you very much. Half past 3, please. Thank you. Right, would you ask Dr. Lane to come back in, please? All right, Dr. Lane, now then, maybe the last lap,
Hopefully.
or at least the penultimate lap, probably.
Yeah.
Yes, Miss Grogan.
One mini topic and then the last lap.
Okay.
We finished Regulation 38, but in your Regulation 38 report, you have also looked at the building control process in paragraphs 14 and in sections 14 and 15. We've not been through that with you today, but there's just one point I'd like to pick up, which is about the consultation with the fire authority. So on page 149 of that report, which is the BLARP 221, at 15.5.22, you talk about the consultation with the fire authority, and you say it's not clear to you why RBKC and the fire authority considered the terms of the consultation to be limited to matters to B1 and B5, and then you say it's not your experience of how fire strategies have been dealt with.
Yeah.
And I just want to ask you about your experience. Can you tell us what your experience has been?
Yeah, so as I hope this is my very latest version, because also I've written here, Lindsay Seal produced a second witness statement and clarified the situation regarding a more encompassing need to consider all the parts together. And that is my experience when I've been asked to participate in such consultations.
So just to summarise Ms Seal's evidence, and we took Ms Menzies to it.
Yes.
Because she hadn't updated her report.
Yeah.
Inspecting officers are more likely to offer observations in relation to B1 and B5, but there's no restriction or limitation
Oh, exactly.
on
Yeah.
what they should and do consider.
Yes.
She thinks it's more likely that the fire engineering group would comment on B4 rather than local officers.
Understood.
And she said that in the context of Grenfell, as no problem with B4 had been flagged in the consultation because of what was said in the ICSOVA outline fire safety strategy that you've been looking at for the last 2 days, there would be no reason for LFEPA to comment on that aspect of the design.
Understood. And okay, sorry.
And does that reflect your experience that if a problem with the design is not specifically flagged,
Yeah.
then they won't comment on it?
Well, I don't know that I'd use the word problem, but we talked a lot about the fire strategy and this issue of writing down what's maybe a deviation or not. That's another reason why it's so important. So I have had really detailed discussions with the fire engineering group at LFB on the subject of B4, because of some very specific reasons on a project I may be working, and I draw it to everybody's attention, and then we enter into technical conversations about it. That's why a fire strategy needs to be clear on complex issues, or limits, particularly when you're working on an existing building and you're restricted sometimes in what you can achieve.
Thank you. Moving on then to CDM. And that's in your other report, which is BLA RP2 5016.
Yep.
And we're going to start this topic by looking at an overview of how the CDM regulations work with respect to the health and safety file.
Okay.
So you set out the purpose of the CDM regulations in 1.1.3 of your report, which is on page 6. And you say there, it's as described in the regulations, they're intended to protect persons from health and safety risks arising from construction work through this establishment of a systematic framework for management of those risks.
Yes.
And in your experience, are they most relevant to health and safety and welfare during construction projects, or do they have an application after construction projects are finished? So is it just a focus on construction works while they're happening?
They protect people during construction, and Sorry, I'm just struggling a little bit with the question. They protect people during construction. Do you mean when there's no construction, or?
So you obviously have a system where you have construction works as they're happening. So whilst
Yes.
building work is going on,
Yes.
are they limited to that particular period when building work is going on, or do they have relevance outside of that period?
So when there's no building work going on in an existing building?
Yes.
No, but no.
I just wanted to clarify what their scope is.
Okay.
In section 2 of your report, which starts on page 11, you give an overview of the history of the CDM regulations. And this is relevant because your report looks at earlier works as well.
Yeah.
And just to summarise, and you can tell me if I've got this right, the first CDM regulations were the CDM regulations 1997. I think that might be a typo, it should be 1995. 1994. They were replaced by the CDM regulations 2007.
Yes.
And this is where we first see a reference to a health and safety file, is in those 2007 regulations. And if you need to refresh your memory, it's at 2.13 of your report.
I'm just frantically trying to read the regulations in my mind from before 2007. Do you want to?
Do you want to go to page 11 of your report?
Yes,
Do
please.
you think we need to spend too much time on the history
Yes.
of
History? No, we don't. It's just to outline, the point is, and Dr. Lane can confirm, that for the primary refurbishment, we started with the 2007 regulations applying,
Yes.
and then there was a transitional period and the 2015 regulations applied
Yes.
before construction works finished.
Yes.
Supporting the different versions of the CDM regulations, there are approved codes of practice.
Yes.
For the 2007 regulations, there was one approved code of practice. And you've provided an excerpt from that on page 15 of your report at 2.4.6. And this is just to understand the status of an approved code of practice.
Yeah.
And the second paragraph in italics there says it has a special legal status. If you're prosecuted for breach of health and safety law and it is proved that you do not follow the relevant provisions of the code, you will need to show that you've complied with the law in some other way or a court will find you at fault.
Yeah.
And was that your understanding at the time they had a special status?
Yeah, that's my understanding.
As explained there. And for the 2015 regulations, if we go to page 16, there was a health and safety executive guidance document, so
Yeah.
not an approved code of practice,
Yeah.
called Managing Health and Safety in Construction. And at 2.4.11, you've quoted there from its explanation of its legal status. It says, it's issued by the Health and Safety Executive and following the guidance is not compulsory unless specifically stated. You're free to take other action, but if you do not follow the guidance, you will normally be doing enough to comply with the law. Health and safety inspectors seek to secure compliance with the law and may refer to this guidance.
Yeah.
And you said elsewhere in your report that there was an intention from the HSE to produce an approved code of practice, but that didn't happen.
Yes.
In your mind at the time, is there a difference between the approved code of practice and this guidance in terms of how you should use it and whether you should follow it?
Well, so I would reflect on what the HSE themselves say, and in the absence of any other form of guidance, I would still be quite focused on their non-ACOP publication, waiting for the ACOP to arrive.
Paragraph 2.4.16, so on the same page, just a bit further down, you've said that in your report, the approach you've taken is if the duties set out in the CDM regulations, approved codes of practice, or in the 2015 guidance document have not been discharged, you will treat that as a breach of the CDM regulations.
Yeah.
And again, can you just explain why you've taken that approach?
I wanted to be clear the basis of my analysis and the technical opinions I gave in my report.
Is it your understanding that where somebody hasn't complied with the guidance or an approved code of practice, it is in theory possible to demonstrate compliance by another means.
If they demonstrate compliance by another means, yes.
And with a health and safety file, how relevant is that alternative route to compliance? Does it arise in practice?
I
Is it
honestly don't
practical?
even understand the concept of an alternative route to compliance when it comes to a health and safety file. I don't even know what that would be.
That's helpful, thank you.
Yeah.
And have you seen any suggestion in the evidence that you've reviewed that an alternative route to compliance was contemplated by those working at Grenfell?
No, can I just say something? So the ACOP and the regulations are quite simple in a way, with very simple lists of things you need to provide in a health and safety file. And it's literally about putting them into a place together. I don't know what other alternative there could be. So I don't want us to overcomplicate putting information into a file, following a list. Sorry, I probably just sounded very rude there. I didn't mean to sound rude.
It's very helpful.
You know, so I can't get into a big alternative compliance like we might about approved document B, where there are other British standards with some very complex numerical analysis, for example, to comply. A health and safety file, again, is just about relevant information being gathered. I hope that's okay. Yeah.
That's very helpful,
Yeah.
thank you. So in your report, you're focusing on the parts of CDM regulations that deal with information related to fire safety. So that's what you've been looking at in your report. You've been looking at
Yes.
pre-construction information, the construction, you've mentioned the construction phase plan, but not looked at that in depth. And
No.
then you've looked in depth at the health and safety file.
Yeah, so what you give at the end of the project.
And just for reference, if we go to page 13 of your report, there you explain what
Yeah.
these different things are. And we don't need to look at them in any great detail, but
Yes.
just to know that there are 3 sets of information contemplated by the CDM regulations: pre-construction information, a construction phase plan, and then over the page, you've explained what a health and safety file is.
Yeah.
And in terms of terminology, again, for clarity, I just want to run through a few key terms and
Yes.
have you
Yes.
help identify what they are. A number of duties in the CDM regulations, both 2007 and 2015, apply to the client.
Yes.
What is the client under CDM? So who is the client in general terms?
Well, will you put up what the CDM regulations provide a definition?
Yes, we can do that.
Yes, please. Yeah.
1 second, I'll find the reference. So I'm just trying to, we can come
Yeah,
back.
if you scroll, okay. Yep.
Do you think if we scroll down, we'll find it in this section?
Yeah, because all the duty holders under the CDM have a definition.
Yes.
So I prefer just not to paraphrase and get it wrong.
Yes.
Yeah.
I think it will be in section 2 of your report.
Yeah.
We'll keep, someone will find it for me.
Yeah.
I'll skip over then that kind of key terminology.
Yeah.
Going on then to the requirements of, here we go. It's,
Yeah.
if we go to INQ 30111316 and page 2, these are the CDM regulations themselves. And you'll see there it says client is a person for whom a project is carried out.
Yes.
And for Grenfell, for the primary refurbishment, who was the client?
The KCTMO, as I understand things.
We also have, it won't be in the 2015 regulations, but there's something
Yeah.
in the 2007 regulations known as a Cdm Coordinator.
Yes. So yes.
We'll look specifically at their duties relating to the health and safety file, but who was that on Grenfell? Who held that role?
It was Artelia, sorry. Yep.
And if we go to page, I think it'll be page 3 of this document, you'll see there's a principal contractor. It'll be over on the next page, page 4. Principal contractor, just at the top, means contractor appointed to perform the specified duties in regulations 12 to 14.
It was, yeah,
And again on Grenfell, who was the principal contractor.
Ryden.
And in 2015, the role of Cdm Coordinator ceased to exist and there became something known as a principal designer. And again, just to summarise, we know, and it's set out in your report in detail,
Yeah.
that ultimately the TMO took on that role of
Yes, they
principal
did.
designer.
Yes.
And you've already been through with Ms Grange earlier today about the idea of a designer under the CDM regulations,
Yes,
and you've explained who may or may not have that role.
Yeah.
Going on then to the health and safety file itself, can you just summarise what the purpose of a health and safety file is? So why do we have health and safety files?
So when you go to do other work in the building, you can safely do so. And there's different types of work that you might need to do. So I'll just talk about my own experience, if that's okay. So if I'm sending a team of people to do an existing building inspection, we will need the health and safety file to understand, for example, if or where the asbestos is located. And we would read about that in the health and safety file when we're preparing our own risk assessment to attend site. Other parties, if they're doing minor or major works, need to understand where different components of the building are located, including fire safety features, so that they can either rely on them or not disturb them when they're doing the work.
And you've explained in your reports, and I'll just give the reference for the transcript, at 4.3.10 to 12 on page 31. You've explained that CDM 2007 required preparation of a health and safety file where a project is notifiable.
Yes.
And that has a specific concept in the regulations.
Yes.
And Grenfell was a notifiable project.
Yes.
So a health and safety file was required.
Yes.
And it was the duty of the CDM coordinator to produce that health and safety file and to liaise with the principal contractor regarding the contents of the file and the information that the principal contractor needs to provide.
Yes.
And if there's no health and safety file at the start of a project,
Yes.
The CDM regulations required the CDM coordinator to prepare one.
To start preparing one, yes.
Yes. And the client, designer and contractor all have duties under CDM to provide the CDM coordinator with relevant information.
Yes.
So they work together to
Exactly. Each duty holder has to play their relevant part, and that's defined in the regulations.
And then we know that after 2007, CDM 2015 comes in and has a transitional provisions in place.
Yes.
And again, just some basic structural points that we all understand.
Yeah.
Under those regulations, the CDM coordinator remained in position until a principal designer was appointed or the project came to an end.
Yes.
And there's a duty on the client, and this is, again, for the transcript in your report on page 42, there's a duty on the client to appoint a principal designer before October 6th, 2015, and if they fail to make that appointment, then the client themselves becomes the principal designer.
Yes.
And at 5.5.17 of your report, which is again on page 42, there were duties on the CDM coordinator during that period, including to liaise with the principal contractor over the contents of the health and safety file, and if there was no health and safety file, then to prepare it. So
Yes.
even during that transitional
Yes.
period, there was an obligation on the CDM coordinator before they stopped doing,
Yes.
before they stopped being.
Exactly. Yes.
that role.
Getting everything ready. Yes.
Great. Now looking at the contents of a health and safety file, you've identified in your report in section 5.7 that the guidance from the Health and Safety Executive about what it should contain hasn't changed from 1994.
Not really. No. No.
And if we go to page 48 of your report, please. at 5.7.16, you set
Yes.
out, if we just pause with the page zoomed out like that, that's the big list of information that you need to have in your health and safety file.
Yeah, yeah.
Yeah. And then at 5.7.16, if we go over the page, the most relevant requirements to fire safety are B, any hazards that have not been eliminated through the design and construction processes and how they've been addressed.
Yeah.
The nature, location and markings of significant services, including underground cables, gas supply equipment, firefighting services,
Yeah.
and information and as-built drawings of the building, its plant and equipment.
Yeah.
And those are the features of a health and safety file that you focused on in your analysis.
Yes.
Can you briefly explain how the obligation to produce a health and safety file ties in with the obligations we've just been looking at under Regulation 13? So is there an overlap in the kind of information that you should be providing?
In Regulation 13,
Sorry, 38, I misspoke.
overlap with the
Yeah.
duties of
So-
Regulation 38.
How does the health and safety file
Yeah.
fit with Regulation 38, if
Wha-
at all?
Well, it doesn't. They're two different things. They both need some form of fire safety information.
And if we just go to page 8 of your report, you set this out in a little bit more detail. At 1.2.9, you say
Yeah.
both the fire safety manual that we've been talking about and the health and safety file should have been kept available.
Yes.
And at 1.2.10, BS 9999 gives a bit of guidance and says, depending on some circumstances, the fire safety manual might need to be separate
Yeah.
from the safety plan required by the Construction Design and Management Regulations 2007,
Yeah.
in which case the information from this should be duplicated in the fire safety
Yeah.
plan.
I think it means physically separate for whatever reason in a company. Yeah.
And then we've got 1.2.11, so just zoom down the page a little bit.
Yeah.
The approved code of practice again talks about the relationship between the two, and it says here
Yeah.
about the health and safety file, it can be combined with the building regulations logbook
Yeah.
or a maintenance manual, providing it doesn't result in the health and safety information being lost or buried.
Yeah, exactly. So it's, as we spoke about in Regulation 38, it's not about having whole bundles of the same information with different titles. You can have one source and just clearly reference it. The health and safety file, by my experience, and that's why I wrote that specifically in my CV, tends to be a separate formal part of the building manual, and they are there together.
I'm now going to move on and look at what happened during the Grenfell primary refurbishment, and you deal with that in Chapter 9 of your report.
Yeah.
We probably don't need to go there, but to understand how the whole story works, you need to first look back at what happened before the primary refurbishment
Yeah.
to the previous set of works, which was the fire door replacement works.
Yeah.
And what we know, and it's set out on page 78 of your report, is that there was no health and safety file for that set of works.
There was no health and safety file for Grenfell Tower,
Yes.
not for that set of work.
For Grenfell Tower. So
Yeah.
as at the time of the primary refurbishment,
Yeah.
there was no health and safety file.
Exactly.
And that triggered the requirement for the Cdm Coordinator
Yeah.
to prepare one because none existed.
Yeah. So it was required to exist. It didn't exist. And so at the primary refurbishment, now there was a duty to commence that process.
And you've said at 9.7.4 on page 105 of your report that Artelia noted that in their pre-construction information.
That's correct.
And said there was no existing health and safety file.
Yes.
Should that have raised any alarm bells with them at the time? Should that have concerned Artelia that there wasn't one, or was that a relatively common occurrence? at the time?
But I think they were very clear about that there was none, and then they did set out the contents of one.
In your experience, was it common for health and safety files to be absent at this time? So in 2012, was that common across the industry?
I have no idea about the whole industry and health and safety files.
Have you ever come onto a project where there's been no health and safety file?
I have been asked to send staff to buildings with no health and safety file. And then I have to obtain the information a different way, so it is safe for them to enter.
Turning to the relevant guidance, you've set out a quote from the approved code of practice on page 106 of your report. So that's 9.7.14.
Yeah.
And it's the text in bold. It says, for this to happen, CDM coordinators need to make appropriate arrangements at the beginning of the project to collect and compile the information that is likely to be needed for the file as work progresses. So in layman's terms, they need to get started on a health and safety file as soon as they're appointed.
Yes.
At 9.7.17, which is a little further down that page, you quote from Regulation 22. Oh, no, sorry, it's the next paragraph. You say that the approved code of practice makes it clear that KCTMO as client should make sure that the CDM coordinator compiles the file.
Yes.
Is there evidence of Artelia taking steps to compile the file at the outset of their appointment?
Not that I could find in the evidence.
Was there a file in place at the time the regulations changed in 2015?
Not that I could find in the evidence.
Should there have been a file in place at this stage, or was it acceptable to wait until completion to finalise it?
My understanding of the 6-month transitional arrangements was actually to stop that from occurring. So instead of having one regulation on a Friday, jumping straight to the next regulation on a Monday, and the complexity that would cause on a project, the HSE, if you brought in the 6-month transition to allow that preparation. So
was the idea that you would have, during this 6-month period, if you didn't have a health and safety
you
file
had time
already,
to prepare.
you'd have time?
You had time to prepare because the duty holders were changed, the duty holder definitions were changing, and that was complicated.
Yeah. So the idea was that a principal designer, once they came into existence, should have had a health and safety file to work from if there were works ongoing.
Yes, that's correct. Yeah.
Right. If we could go to ART 406299. This is an email from Paul Burrows to Claire Williams dated the 28th of April 2015.
Yeah.
And he says he'll be managing the process, but that the health and safety file may be completed by one of his colleagues, because you'll see the subject line says Grenfell H&S file.
Yeah.
He then goes on to say, to be honest, it's rare to receive information during the project. It usually comes through at the end when there's little or no likelihood of it changing.
Yeah.
Does that reflect your professional experience of how health and safety files would be prepared at the time?
It can be last minute. The let's say the as-built information you would need in the health and safety file. However, I am used to, there's something called the Cdm register where designers raise, risks they may not be able to mitigate or require attention even after handover. My experience is that I have been asked by Cdm coordinators throughout a project to keep that part up to date.
So that was that first chunk of text we saw when we looked at what needs to be in a health and safety file, and the information that's particularly relevant to fire is risks that haven't been mitigated.
Yes, so the health and safety file will contain as-built information. So obviously there's no, it has to be built to become as-built to go into the file. There are some more dynamic processes around tracking residual risks throughout the design period that I would expect to be more accurate. And the preparation of the file, getting ready for the as-built information, again, Remember, there's lots of information, lots of parties, so there is work needed setting up the structure, who's going to be responsible for what, and getting ready to obtain any last minute information as well. You don't do it in the last week because there's too much to do.
I just want to look at some of the oral evidence. Mr. Cash's evidence on day 49 at page 80, please. Now, as it's loading, he's being asked questions by Mr. Millett about 2013, so that initial stage when there wasn't a health and safety file before these transitional provisions kicked in.
Yeah.
And at line 10 he says, now in the circumstances where there was no health and safety file for the Grenfell Tower at that time, so November 2013, would you have expected Artelia to produce one? Mr. Cash says no. Why not? Because those regulations refer to not only refurbishment projects but also to new construction projects where there wouldn't have been a health and safety file. What it is saying is that the obligation is to produce one, but it doesn't say when. As is normally the practice, the information for the health and safety file is amassed during the project, and the health and safety file is produced at the end of the project when all the information is available and there are no further changes to be made to that information. Is it your understanding of the regulations and guidance that there is a distinction between new build and refurbishments in terms of when a health and safety file?
I think the regulations themselves make that clear.
And that's that there's no distinction between the two. If you
It says the health and safety file has there has to be a health and safety file for an existing building by the very nature of the fact that work was done, the building now exists, there needs to be a health and safety file.
But if there isn't one, there's no difference for a refurbishment project. You've got to do one, and as we've been through, the guidance says you should get on with it.
Yes.
Is that your understanding?
Okay, so sorry, do the regulations say for refurbishment you can wait to the end?
Yes.
No, it doesn't say that at all. Yeah.
Mr. Cash's evidence was that he didn't think one had to produce one until the end.
Yeah.
You just answered that question.
Yeah.
And again, you have answered this question in part. What kind of information would have been available during the course of the project?
Yes.
And in particular, before Artelia ceased to be Cdm Coordinator, that they could have put in a draft health and safety file? What types of information? So I'm not asking for you to identify specific documents, but in principle, was there information out there that could have been compiled at an earlier stage?
I have not looked at what everybody was doing every week, the state of completeness of the construction, and which documents should have been ready in what week.
Okay.
Yeah.
Moving on now to the appointment of principal designer. We've been through how that worked in principle, and also that ultimately the TMO concluded that it would fulfil the principal designer role. You've looked at that chronology in quite a bit of detail in your report, and for the transcript it's 9.8.22 to 9.8.53 of your report. We don't need to go to it, and we've got to the ultimate conclusion. If we go to page 115, and we see there you've provided a little summary of what happened.
Yeah.
And that goes over the page.
Yeah.
And through that process, you've noted various internal communications within
Yes.
Artelia about this issue. Are you critical of Artelia's handling of the process of handover to the TMO?
Critical. Yeah. Can we go back to the page?
So back
Let's
to
go
page
back a
115.
page. Am I critical? Well, I set out what I observe in the evidence. I believe that, you see, point A,
Yes.
that 2nd of February email, I think that's the Keith Bushell email to his colleague saying this project is not going to be handed over before the 6th of October.
Yes.
Okay? So there's an awareness the transition period is coming and that work needs to be done. And I reviewed the evidence to understand what work was done, and I couldn't find any.
And is that something you feel you are able to give an expert opinion on, whether that falls below the standard of a CDM coordinator, or is that something that's out with your expertise?
As I said in my report, I recommended the inquiry took advice from a CDM expert if they wanted to explore that any further.
Thank you. Later in your report, at 12.2.7 on page 170, you note that it's of concern. If you zoom in, you say it's of concern that the TMO accepted the role of principal designer when Claire Williams retrospectively acknowledges that she wouldn't have had the technical expertise to assess whether it complied with the statutory guidance. Did you hear Miss Williams' oral evidence?
I mean, I did listen to her, but
Has your view changed at all on that?
Well, look now, I didn't listen to her evidence in full and have a big think about how it impacted my report. So if you need me to do that, I shall.
Some related questions to that. Is it fair to say that the TMO had to take on this role by default because nobody else on the project had agreed to take it on? Perhaps if I put it another way, were there other options?
I was just trying to think. Sorry, I wanted to. So, as a director of a multidisciplinary design company, I have to talk to my clients about CDM regulations, beyond, say, fire safety information. And I and others would really strongly advise our client not to take on that role. That's what I was trying to think of a way of putting that. Mm-hmm.
In those circumstances, were there other options available to the TMO? So where the other members of the professional team, so Studio E, Ryden, Artelia, had all said, we don't want to take on this role, was there another option, a third party, for example?
So I'm not going to stretch into anything like that, except to say to you what I said in my report. Remember, I listed out all the other companies they contacted who the TMO considered to have the skills to help them, and that was another approach they could have taken.
So we've already noted that there was no health and safety file handed over to the TMO at the end of that transition period. At 9.3.37 of your report, which is on page 119, and I know we're jumping around a bit.
No, it's okay. It's okay.
In the report.
Yeah.
You say that the ACOP made it clear that KCTMO's client should make sure the CDM coordinator compiles the file.
Yeah.
Therefore, it's your opinion that the TMO were also responsible for a lack of a health and safety file at the end of the transition period.
Yeah.
Could you just expand on that?
Expand
so
on that?
Why do you say they were also responsible?
Because they were the client.
And that's because they have duties under the CDM regulations to ensure that things are done.
Yeah, exactly. And the CDM regulations, I mean, I think maybe I might add to my report with the table showing all the different things that's assigned to the client uniquely in each set of regulations.
Mm-hmm. And it's a distinction, as we've explored from Regulation 38, that the client here actually has a regulatory duty. They're
a duty holder under these regulations. And they have a really central role as defined within the regulations. It's not my opinion. Yeah.
We've already looked that the TMO asked Ryden to collate the health and safety file, and Ryden then subcontracted that work out as well to All Group Holdings.
Yes.
And is it your understanding that whilst Ryden agreed to carry out this work and to engage an external company to collate that information, the statutory duty to produce the file at that stage, so after the expiry of the transitional period, rested with the TMO?
Yes.
Because they were principal designer.
They made themselves principal designer, and by doing that, they gave themselves that duty.
Mm-hmm. I've already asked you these questions with respect to Regulation 38 information, but for clarity, how common is it for third parties to be engaged to collate information for a health and safety file?
So,
in your experience?
yeah, so as I've explained, my experience is the health and safety file is a part of the building manual, and I have worked with principal contractors where they've employed another organisation for information collection.
Mm-hmm. And you say information collection, is that they go about finding the relevant bits of information? Do they also review it or express any views about it in your experience?
It depends on their appointment.
And you say at 9.3.26 on page 84 of your report that the arrangement between Ryden and All Group Holdings is outside of your realm of expertise to provide an opinion on whether this was an appropriate arrangement.
Yeah.
And can you just again explain what you mean by that? Is that another area where you advise the inquiry to obtain?
I just meant that I don't mean anything other than what I've said. I wasn't trying to imply anything else, sinister or otherwise. Yeah.
Just you are not able to comment on it because it's not within your area of expertise.
Well, I don't, run. I'm not an employer's agent. I'm not a client. I can only tell you what happens to me on a project. Yeah.
In your opinion, and you may say this also falls outside your expertise, what skills would a principal designer need to be able to scrutinise a health and safety file once it had been provided?
Yeah, so I think I really hope I've made it clear in my report, and I haven't strayed into what a principal designer should do. I've only explained, I've only given my views on fire safety information. But the principal designer role, again, is defined in the regulations, and it has become a very substantial role as defined in the regulation. And I can say that because as a director of a multidisciplinary company, we have to make decisions regularly about if we're going to take on that role. But for this inquiry, I'm giving fire safety advice. Yeah.
Let's move on then and look at that aspect of the health and safety file and your opinions on that. If we can look at the health and safety file itself, it's TMOM 401932. So we've heard about it. This is it, the health and safety file.
Yes.
It's 3 pages long.
Yes.
And it's a series of cross-references back to the building manual.
Yes. You've
reviewed those cross-references, and we can see that in table 10.1 on page 129 of your report.
Yeah.
And I just want to look at the top 3 references there. On the left, we've got a brief project description and project team, and you say you've looked and no cross-references are provided because there are separate files in the folder on the USB stick.
Yes.
Containing the building manual that contains that information. B1, Architects As-Built Drawings, that cross-refers to Part 2, Section 2.1.2.2 of the building manual, and you say, however, this section does not exist.
Yes.
Again, B1, Pre-Construction Information, the cross-reference doesn't exist. And C1, again, the cross-reference doesn't exist.
Yes.
And that's your analysis, again, of the building manual handed over to the TMO provided to you in February 2020.
Yes.
So it's that USB stick.
Yes.
And that's a theme, isn't it,
Yes.
of your analysis, that the cross-references don't actually relate to sections
Yes.
in the building manual.
Yes.
You then give your conclusions from your analysis at 10.3.16 on page 130. And I'll just read those. It says, it can be seen in table 10.1 that the majority of the cross-references do not exist or link to incorrect sections of the building manual.
Yes.
You've noted there the guidance from the Health and Safety Executive says that information must be in a convenient form, clear, concise and easily understandable.
Yeah.
And then you say, based on the inaccuracy of the referencing alone and also the scale of documentation provided where the referencing is correct, in my opinion, this health and safety file is not in a convenient form, nor clear or concise, nor easily understandable.
Yes.
In your opinion, was it appropriate to have a health and safety file that took the format of a reference document? Or perhaps I should ask, in your experience, is that something that was done? This referencing type of health and safety file?
Typically, I'm given a building manual and I go to a section of it to get relevant health and safety information. And so, yes, it might reference other parts of the building manual. I'm thinking about other health and safety files I use, and they are actually complete. So I've seen both forms.
At 10.5.5 on page 145, you give your overall conclusion
Yeah.
that the health and safety file was substantially non-compliant. Does that remain your view?
Yes.
And this is a summary here of your analysis, in particular of the items relevant to fire safety. So point A, you say no residual hazard registers are provided,
Yes.
and therefore the reader cannot understand what hazards may remain and must then be managed over the future life of the building.
Yes.
Yep. So that was, we looked at that earlier in the list of things that needed to be provided.
Yeah.
You singled that out as one of the items relevant to fire safety.
Yeah, because,
And
yes.
we've tracked that through now to your conclusion.
Yeah.
There was nothing there addressing that.
I haven't found one in the health and safety file, and it's a duty to have one in the file.
I just want to look at the evidence of Ms. Williams on this point. It's day 56, page 132. And we start at line 19. And she says, but can I point out, the issue with our building was that we had an existing part of the building that Ryden were not involved with. They were not involved with water tanks in the roof. They were not involved with several, well, let me just think. There were areas of the building that were existing, and then over the page. So whatever Ryden provided would only be partial information in terms of the health and safety file. And then she goes on and she says at line 6, so Ryden were never going to provide complete information for that health and safety file, because I think that's quite important to mention, because the building contract, as I say, only covered elements of the building. It didn't cover the whole building. So her evidence is she wasn't expecting complete information from Ryden.
Yes.
If you focus only on the Ryden works, sorry, let me just ask these questions in a slightly different way. Having reviewed the documentation and evidence, the building manual that you've looked at, was it your understanding when preparing the report that Ryden was only providing information relevant to its scope of work?
So
So in,
all I've done is understood fire safety matters that are part of the primary refurbishment, which was extensive and don't include water tanks, and then gone to look for that information in the health and safety file. If Miss Williams had health and safety file information available to her, I would have to ask why it wasn't provided to Artelia when they drafted the documents they did at the start of the project. Probably it's worth me saying now that I listened very carefully to that part of Miss Williams' evidence, and I am currently investigating Keystone and the other servers at the TMO to try and find all this information that wasn't provided to, apparently not provided to the professional design team at the time, even though it was a duty of the client to do so at the time.
so that's something that the inquiry might have to come back to with you once you've completed that
Yes,
investigation.
because it's relevant. Yes, that's correct, yeah.
If the panel accepts the evidence that the health and safety file produced by Ryden or on Ryden's behalf was only intended to cover Ryden's own works, does that affect your conclusion that the health and safety file was substantially non-compliant?
No, because I was thinking about Ryden's health and safety file.
And a number of places in your report, you said that matters were presided over by the TMO.
Yes,
What do you mean by this?
because the KCTMO are the client, and the CDM regulations puts the client is a duty holder, but it's a very specific type of duty holder. They make the appointments, they set up the other duty holders, they make the appointments, they have to have information available to them, they have to track what's happening. So they have a distinct role. And for the KCTMO, any project, not just the primary refurbishment, that fell under those regulations, there may have been different CDM coordinators over the years. So CDM coordinators come and go. The client is the client and has been the client. And that's what I mean when I chose the word presided.
And if we can see that at 13.6.12 of your report on page 191, you make this point. And you say there,
Yeah.
however, the common duty holder for all the works was KCTMO, and they consistently failed to create
Yes.
or enable a process that complied with the CDM
Yes,
regulations.
that's my reading of the evidence, yes.
And from a fire safety perspective, that's your opinion as well, that they
Yeah,
were
so
responsible.
but that is my opinion. I've made that clear for each one of the works. I've looked for the relevant fire safety information in the health and safety file and tried to find it and have not found it.
The next and final topic we're going to look at is the question of availability
How are
on
we
the
getting
night.
on? I've just got one eye on the clock.
Yes,
Yeah.
I do as well, Mr. Chairman. We only have, I will be finished by 4:30 with these questions.
But then we shall have the usual.
We shall have the break, and I am sorry to have to overrun,
All right.
but it is a short topic.
Good. Yes. Thank you.
So in this next topic, we're looking at the issue of what documentation you consider should have been available on the night of the
Yes.
fire. Going back to the Regulation 38 information, and if we go back to the words of Regulation 38 first, which is on page 9 of your BLARP 221 report, page 9. We've already discussed that Regulation 38 is for the purpose of assisting the responsible person discharging their duties and to understand the operation and maintenance of the building. The regulation itself doesn't say that fire safety information needs to be available for the purposes of operational firefighting, does it?
No.
No. If we now go to your CDM report, so that's BLARP 216 at page 7, you've quoted from BS 9999, paragraph H3, and it says 1.2.6, so it's over the page on page 8. At the top, the fire safety manual should be made available for inspection or test by auditors and regulators and for operational purposes of the fire and rescue
Yes.
service.
Yeah.
So that's where you get the concept that the Regulation 38 information should be available
Yeah.
for the fire service.
So I just think it's worth me explaining that the operate and maintain under the the Regulatory Reform Fire Safety Order, there is a duty there around emergency planning, and it requires the responsible person to communicate with the brigade in that specific regard. And that's why the British Standard would remind people why the manual needs to be available for the brigade in that context. So,
And you then say at 1.2.7 that the TMO had a statutory duty to make the fire safety manual available on the night of the fire. Is that your understanding of how BS 9999 works together with Regulation 38?
So under the RRO, you have a duty to provide fire safety information to the brigade for the purposes of emergency planning. And and that's in a very particular context. It's not the context that was dealt with in phase one. So I'm not going back there. It's about communicating information in a particular way to make arrangements before a fire occurs.
And is it your understanding that where there is a fire, so where operational firefighting is taking place, the fire safety manual should be available for the purposes of the LFB?
If the fire brigade call for information related to fire safety for the building that they're in, the responsible person needs to be able to communicate that.
And that comes from their duties under the RRO.
Yes,
doesn't
it
come
does.
from Regulation 38. I'm
Yeah.
just trying to understand how you understand this all works based on what you've said in your report.
Yeah, it's to do with the it's to do with the RRO, and Regulation 38 is all about connecting to the RRO.
With regard to whether the health and safety file should have been available to the LFB, you set out your opinion on page 9 of this report at 1.3.7 and 1.3.10. And to summarise what you say there, there's no obligation in CDM that the health and safety file must be available for the operational purposes of the fire and rescue
That's
service.
correct, yeah.
There's nothing in the approved codes of practice or the HSE guidance that says it should be available.
That's correct.
But you don't think it's unreasonable to expect that if the fire safety manual was not available, for whatever reason, the health and safety file could be made available and relied upon instead?
Yeah, so at Grenfell Tower, they had one source of information, which was the building manual, and it was meant to contain fire safety information for whatever particular regulation you're thinking about. The fire safety information was relevant to the brigade.
And in your opinion, information relating to compartmentation, location of firefighting equipment, fire protection measures provided, and gas supply equipment was information relevant to the fire brigade on the night of the fire and should have been immediately available by means of the health and safety file?
Yeah, as was a building description, which would include the flat numbering system, the story numbers. Yeah.
And when you say immediately available, the word immediately doesn't feature in the guidance. Is that just a practical point you're making, that it should have been something at the TMO's fingertips?
Yes.
In the middle of the night, without any prior warning.
If a responsible person is asked for information, why would you not know where the information was?
Well, what's turning through my mind is
Yeah.
that making the file available to the fire brigade for operational purposes
Yeah.
is likely to be more usefully done well ahead of any fire, so that they can extract the information
Yes.
that is really likely to be useful to crews on the ground,
Yes,
which they
agreed.
can then feed into their
Yes,
systems
yes.
and have it immediately available.
So the whole file, in
Well,
my
the whole
mind...
file's very large, isn't it?
Exactly.
Yeah.
So it's very large. In my mind, I was thinking very particularly about the drawings, which, as you know, I explain in my report, and how long it took to find them, which I don't understand, including in the middle of the night, in the middle of a fire.
Yeah.
And in Module 3, we will be talking about KCTMO's emergency planning arrangements, and we will need to come back to this.
Yeah.
So I don't mean arrive with a big massive file in the middle of the night at all, but I'm talking about very basic information being available rapidly. And yes, I think that what's the point in having the information if you couldn't make it available in the middle of an emergency, because that's exactly what the information is for.
That's helpful, thank you. But it's right, we can't take it any further than that. It's not for you to speculate on what the effects might have been had that been available. So you can say you think it should have been available. You can't go any further and say if it had been available, this would have happened differently. Or
I haven't said that, you've said that. Yeah.
And I'm confirming with you that you haven't said
No, I'm not planning on saying anything else other than what's in my report.
that. So just one final question from me. Bearing in mind your conclusions on the adequacy of the health and safety file and compliance with Regulation 38 in terms of fire safety information,
Yeah.
why is it that you think it's important for these failures to be investigated by the inquiry?
I was trying to explain that it's like a circle of compliance. You've got your CDM regulations, you've got Regulation 38, then you've got the Regulatory Reform Order. What it's trying to do is transfer relevant fire safety information around that circle to protect people. And there's two types of people: the people who live or work in a building and the fire brigade. And it's all, and I hate the phrase golden thread, but that's exactly what it's about. It's simple, easy to find and clear, a narrative about what's in the building to help people during an emergency. That's what it's all about. And that's why I insisted I write another very long report on the health and safety file, because it's another place where, the law asks of us to provide useful information in the event of a fire. That's all I was trying to do. Hopefully somebody will listen.
Thank you, Dr. Lane. Those are all of my questions.
Right, thank you very much. Well, at this point, we have to have another short break.
Am I allowed to just go home at this point?
You
now?
will be going home
Yeah.
before too long. I'm going to say that we'll come back at 20 to 5, but if you need more time, then just let us know.
Yes, and thank you for
All right.
Okay,
bearing with
thank
me.
you.
20 to 5, then, please.
Yeah.
Yes, would you ask Dr. Lane to come back in, please? Right, well, let's see if there are more questions for you. Ms. Grogan?
Just one, and it's more of a correction than a question,
well, there we
so
are.
it should be quick. You mentioned in your evidence on Regulation 38 a letter from the LFB, and I said that it was a letter sent round to the TMO following the Latnall House fire. That was wrong. It's the Shepherd Court fire.
Yeah, no, it was.
So
Because
that was
it's later. It's much closer to the fire.
yeah. So if we
Yeah.
just go to it, it's RBK 30s54198. So is that the letter you were referring to, dated May
Yes.
2017?
Yes.
Tall buildings, external
Yes.
fire spread. If we
Yes.
just go on to page 2, you'll see there the advice from the LFB is they'd strongly urge you to consider this issue as part of risk assessment
Yeah.
process for premises, suggest you make sure that all relevant information about any replacement window and facade schemes is fully available to fire risk assessors.
Yes.
And is it right that it's that information that you're saying the TMO did not have in its possession to be able to...
I said
Said.
that in the evidence I've looked at so far, I didn't see them go to the building manual when this very important question was asked.
Yes,
And that's where that information needed to be.
yes. Thank you. That's it.
All right.
Yes, thank you very much.
Good, well done.
If we could just, we would like to, I know you will as well, thank Dr. Lane very much for coming and for assisting us with our investigations.
No problem.
Yes, well, I would certainly endorse that, Dr. Lane. Anyone who's seen any of your reports
Yes.
will realise how much work has been put into
Yes. Yes.
this. It's a tremendous effort,
Yes.
and we're very grateful to you.
Yeah, no problem. And just to acknowledge, as always, the named people who have assisted in all the
Yes.
investigations incredibly.
Yeah,
Yeah.
we've seen that, but as team
Yes.
leader, and I think you can
Yes.
take
Yeah.
you can take credit on their behalf.
Okay, and for
That's a
them.
huge
Yeah, well,
amount of
thank you
work.
very much. Yes,
Thank you for being here. We'll no doubt see you again at some stage.
I'm sure you will.
And
Yes.
now you are free to go home.
Oh, thank you. Okay, thank you.
Right, well, that's it for today.
Yes.
And we resume on Monday at 10 o'clock.
We
Another
have,
expert, is that right?
it's the afternoon that we're resuming, so we have Mr.
Oh.
Hyatt,
I'd forgotten. that. You're
and
quite
yes, there
right.
has been that timetable
You're
change.
quite right. So 2 o'clock.
Yes. See you
Right,
then.
well, that's the end of the hearing for today. We shall resume at 2 o'clock on Monday.